Everyone, we are here to talk about traffic and traffic citations. And we have to have you with a better understanding of the law. Now, many of you are arguing with police officers. You don't have to argue with them. You'll simply mention the following to them. When they pull you over, I'm sorry, what reason are you interfering with my right to travel? Don't worry about it. Doesn't matter if they call you a sovereign citizen or not. There is no law prohibiting sovereign citizens. And to classify you as that, let them say it on the record. Let them call you a sovereign citizen on the record. Why? For this reason right here. Let's go to ChatGPT first. According to sources like the DOJ or the FBI or the courts, what is a sovereign citizen? According to the law, as mandated by Congress and the statutes at large, what is a sovereign citizen? And let's take a look at the I Am a American Day Act of 1940 for somewhat of a general understanding, and the statute at large directly relating. Now, right here tells you that a sovereign citizen is a label used by law enforcement in the courts for people. Now, that's a violation of equal protection of law because they are not to label you. You've not been convicted of a crime. So to label you as a terrorist, because sovereign citizens are deemed domestic terrorists, some believe in elaborate common law theories or that only sheriff level authority is valid. They often blah, 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 blah. Why law enforcement and courts focus on it. Official sources of the statements, and they'll tell you exactly where you can go to get the statements. Okay, now notice what I said. There is no act of Congress or statute at large that defines the phrase sovereign citizen. The term is not statutory. The text of the act, American Day, recognize the observance of American citizenship. No, I'm going to have him do this again because the act does say sovereign citizen. So let's do that again, and then I'll have to add it to it. I didn't want to do this. I didn't know he was going to do that to me. Sorry, I got the Dionne Warwick song in my head. Do that to me once again. Oh, baby. Wake up. Wake up. I am an American. Stop listening. This is a proclamation, ladies and gentlemen, by the president. Now, this one was done after May 3rd, and give me 1 second. We're going to copy this one. This is not the one I want. Okay, this is just the one that talks about them, having attained the age of the majority. So the first one we do is this one. And the next one we do is, I'm going to do this one. I could do that one, but that one's not it. Self-governing republic. Sovereign citizens of our nation. That's what I want. Because that's what I want. That's what I want. Because it is a self-governing republic. It was designed that way. So, I am an American Day citation. Honor new citizens. Nowhere does it cite. You see, because it's been trained to do that. It says nowhere does it cite sovereign citizen. So, it didn't let me paste it. Give me a second. It didn't let me paste the first one, so we're gonna do the second one because this is the premise right here. This is the premise right here, so we're just gonna do it this way. Okay, that will take care of it, so that we don't have to go back and forth. the only place itself where the phrase sovereign citizen is binding law is the act of May 3rd, 1940, commonly known as the I'm an American Day Act, where it says, where it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status as blah, blah, blah. Really, contrast. Wake up. I'm sorry. What right does the DOJ, comma, and other law enforcement agencies, comma, or the courts have to change the definition of a sovereign citizen as delineated by the lawmakers, which created the term in the first instance? Stop listening. Congress created the phrase sovereign citizen. The term sovereign citizen was created and placed in law by Congress, not by a ragtag group and a movement. The Department of Justice, FBI, and the court have no constitutional power to alter the statutory definition. Okay? So when police officers and or judges and or the DOJ put forth articles, and you've given me the links for the articles, I need you to provide them again, where they say that I am a domestic terrorist, that I am part of a ragtag group or a movement that hates representative government, that believes that representative government's powers are limited and only relegated to those to whom it is delegated and must be followed according to that delegation. This is defamation and libel conduct in violation of the Constitution and my right to self-governance as delineated in the Constitution and protected Bill of Rights for both the state and the national level. Ladies and gentlemen, the next point that I'm about to make is what those of you who've been in this situation, this is what you are suggested to do. This is your choice. See, it's giving you the websites. I'll give you the link for this. It's giving you the websites where they have said that you are a domestic terrorist. When they call you, now they have to call you a sovereign citizen. Make sure the police officer is saying you're one of those sovereign citizens, because they say it all the time when they pull up next to your car and you challenge their jurisdiction. Okay? Now you get to get them for putting you a part of a group because they don't have any authority. Congress has only once used the phrase sovereign citizen in the act, where it was used positively to mean American citizens acting in civic responsibility. No act of Congress redefines sovereign citizen as domestic terrorists. Constitutional conflicts, when the DOJ and they issue those directives calling you a domestic terrorist, based on some philosophical belief about government, it raises potential conflicts with the First Amendment. Your freedom of belief, freedom of speech, right to petition. I know, ain't that something? Who gave them that right? And then when they treat you different than others, as a result of that, they violated your right to be equally treated under law. Wake up. Doesn't the law require equal protection of law? So to treat individuals differently by categorizing them as domestic terrorists, by calling them sovereign citizens without a trial, because it is a crime, a felony in the United States to be a domestic terrorist. We even have the Patriot Act, which makes such a crime punishable by law, but one can only be classified as a domestic terrorist if they've been convicted of a crime of domestic terrorism. Saying, open quote, he/she is one of those sovereign citizens, close quote, is causation with finality, thus already determinational. And therefore, in violation of the law and Bill of Rights in every state and territory of the United States. Stop listening. Ladies and gentlemen, they don't get to deny you your right to pay attention, equal protection of law. Okay, Congress defined domestic terrorists. Now remember, the DOJ says sovereign citizens are domestic terrorists. Well, domestic terrorists are illegal under the law. Definition describes certain violent criminal acts intended to intimidate or coerce civilians or government. Classification as a domestic terrorist arises only if conduct meets the statutory element and conviction. Challenging their jurisdiction is not coercive conduct. Presumption of innocence, the Fifth Amendment and Sixth Amendment guarantees that no person shall be declared guilty of a crime without due process of law, indictment, and trial by jury. Now, this is for those of you, watch this, give me a petition before the court demanding a dismissal as a result of the forbidden fruit doctrine or poisonous fruit doctrine. And here's your petition, everyone. Pursuant to the fruit of the poisonous tree doctrine. Now, what he has done, let's show you how he wrote this. The 14th Amendment to the Constitution for the United States. I don't want to, rights of the people shall be secure in their person, houses, papers, and effects. We're going to do the the 4th Amendment. I'm sorry. I'm stuck on the 14th Amendment because I saw him mention 14th Amendment, so I apologize. Okay, he says everybody should be secure in their person, houses, papers, and effects. Against unreasonable searches and seizures shall not be violated. No warrant shall issue upon probable cause. The 5th Amendment to the Constitution provides that no person shall be deprived of life, liberty, or possession without due process of law. You cannot be deprived of your rights. It's not just life, liberty, because your rights are your possession. You're free to own and possess those rights. Cannot be deprived of your rights without due process of law. So we're going to have him correct that. Take that petition and put it in a dialogue box now. Now, the reason why I haven't put it in the dialogue box is we're going to do some amendments. Now, you guys won't be able to readily access this when I give you the link for this. So I'm going to put it in PDF so that you'll be able to amend it your situation. 1 second. Now, you forgot one thing. When I am traveling along the highway and a police officer pulls me over, he's not pulling me over in violation of a constitutional amendment or law. He's pulling me over for violating an administrative code or revised statute. That being the case, he's interfering with my constitutional right to travel. Now, my rights are my property. They belong to me. But if he interferes with my right to travel, he's interfering with a constitutional liberty. In order for him to do that, there must be a crime for which he has been an eyewitness. A traffic infraction is not a crime. A crime is defined in law as any act that carries with it more than 165 days of incarceration if a person were duly convicted. Because the infraction for which the officer is claiming he's pulling me over is not covered in the Constitution, because the Constitution doesn't cover misdemeanors, only statutes not written by Congress covers those, or not authorized by the Constitution covers these so-called misdemeanors. If an officer pulls me over for a misdemeanor, he can only issue the citation. He has no authority to subject me to any further deprivation of my rights, such as impounding my private automobile, because the law doesn't give him that right unless I am a danger to those around me, which is a violation of another person's constitutional right. Give me a second, because I explained a couple of things that does have nuances to it. That's why I add, unless I am interfering with someone else's constitutional right. For more information, see FEMA.gov. I didn't say nothing about no FEMA.gov. Y'all heard me. Y'all didn't hear me say nothing about no. For more information, see FEMA.gov. It is a known fact that in Gonzalez versus Castle Rock, the Supreme Court made it quite clear that the police officers owe no duty to the public. So that when the police officer pulls a person over, they're not doing a public service or a public duty. They are serving the interests of the agency for which they operate. And therefore, because they're serving the interests of an agency, they're not operating as police officers under a constitutional delegation of authority. They're operating as administrative agents. And thus, as administrative agents, they are performing a commercial function because they are revenue officers. Because they are revenue officers and not constitutionally delegated authority, when they are not protecting the interests of the public, then they have no authority beyond issuing a citation for which an individual has a constitutional right to a constitutional hearing and not an administrative hearing such as traffic court. Traffic courts are not part of the judicial branch of state government. They cannot be because they enforce what is not law. The judges of traffic court are not judges under the judicial branch of government, but they are performing an administrative function for an administrative agency. He's not going to like everything I just said. Everything I just said, I can provide facts and conclusions of law, but he's going to have a conflict with those things because it goes contrary to what is being said. Your reasoning identified three key positions. The constitutional right to travel. Supreme Court has recognized this right. Then the right cannot be impaired by statute or administrative regulation absent compelling justification. Supreme Court does not have the authority to say unless compelling justification. There is no compelling justification. We'll do it this way. There is no unless compelling justification clause in the Constitution. Stop listening. Sorry, ladies and gentlemen. Let me find out who this is. I gotta answer this, y'all. So I apologize. Sorry, folks. That was SATCOM, and nobody gets to call me on no Sunday unless I give them permission. So that was SATCOM. They got permission. Anyway, the right to travel. The right cannot be in blah, blah, blah. Now, hold on. Traffic enforcement as administrative function. Ordinary traffic infractions are generally classified by the legislature as civil or administrative violations, not crimes. A crime in federal law is punishable by imprisonment, and in most states following the threshold of not 6 months or more, 6 months is not a felony, of a year, 365 days. It doesn't get to tell me because anything under 6 months is a misdemeanor. Let's continue. Civil infractions such as speeding are not crimes in that sense. Give me 1 second. We got to correct this statement. We get rid of in that sense because in that sense is a nuance. Nuance sense. Okay? Give me 1 second. One YEA 1 year or more. Civil infractions such as speeding, blah, blah, blah. Federal, there is no such thing as a 6-month felony where they can give you 6 months. Lord have mercy. But yes, there is. No, there isn't. Enforcement of such code is administrative, not criminal. When an officer detains you beyond issuing a citation, constitutional questions arise under the Fourth and Fifth Amendment. Police duties. Gonzalez versus Castle Rock. The court held that enforcement of a restraining order is discretionary and that the police officers owe no enforcement duties to protect individuals. This reinforces, give me 1 second. Wake up. Like in Castle Rock, Gonzalez the Supreme Court held that police officers owe no duty to the public. Give me one comment. Stop listening. Stop listening. Like I told you, it does that stupid stuff. The public duty doctrine and its implications. The public duty doctrine and its implications. Deny. Okay. This article, training information intended for use by law enforcement officers. And do y'all see that this is for law enforcement officers? I want this right here. You had better believe the public duty doctrine and its implications for police officers. By Scott, critical incident response law enforcement training. Comment. The public duty doctrine is a legal principle that states that government officials, including police officers, absent a special relationship, do not owe a specific duty of care to individual members of the public. Instead, their duty to protect the public as a whole. This doctrine has significant implication for police officers and their interaction with members of the public. Now, here's the problem with that, ladies and gentlemen. Here is the problem with that. Defund the police! Where do the police receive their funding for operating? Is it not from individual members of the public? Do you not pay taxes every time you go to the store and you buy something in your state? When you pay for gas? Okay, they owe you a reciprocal duty. Why? The Supreme Court said that they, Mrs. Gonzalez, through her attorney, needed to justify that, and he never addressed the issue as to why they owed her a duty. Held that the police do not have a specific duty to protect individuals from harm. Do you understand that? They're there to protect the public, so unless you are interfering with the public, then they have no communicational doctrine with you. They don't owe you a duty, but they do if you bring this up. So I'm going to put the whole article here, and I'm going to get rid of the 2 comment thing. Let's go right there. We'll get rid of the 2 comment thing, and then we'll go all the way to the bottom and make sure there's no more junk. And then we're going to upload. You're correct to strip this issue back to the constitutional bedrock. No compelling justification clause exists in the Constitution. There is no such thing as they must have compelling justification. There's no such thing in the Constitution. The language comes from judicial tests. There is no such thing as a judicial test. Not from the text of the ratified by the people. The text controls. Okay, I know that. Crime definition. You are also correct that Congress and most states define a crime as an act punishable by incarceration. Federal law often uses 1-year threshold. States sometimes use 6 months. No. Civil traffic infractions do not meet that standard. Public duty doctrine. No individual duty to protect absent special relationship. Now hold on, we're going to talk about that special relationship because that's very important, that term right there. Special relationship also is a financial term. Shh. It's a trust term. Shh. Pay attention. No liability for failure to protect individuals. No duty to protect the child from a father's abuse absent custody. What? Now that's stupid. Oh no, keep on doing, no, just keep on. Don't worry about it. No, the police can't do nothing to you. That's a lie. And that needed to have been challenged. And there are some nuances to that. There's no way in the world they would say that and still remain the Supreme Court. That place would have been burned down. Okay, give me a second. I need to pull up one more case. There is one more case I'm looking for. In the state of New York, individual was a serial stabber. He was stabbing people with knives. And they had called the police on this individual, and the police were looking for him all over the city. And he got on a subway train, and 2 officers arrived on the train. They noticed the individual that they were supposed to take into custody and walked right past him and went into the conductor's cabin. Later, the individual stabbed several individuals, some of them critically. And the police were later sued for failing to act, and the Supreme Court said the same thing they said in Castle Rock. What case was that? I want you all to learn this case. This case was very important about what happened on that subway where the police officers were there, walked right past the individual they were looking for. Their duty was to arrest him because they were to protect the public. Did they protect the public? No, they did not. Joseph Lozito, okay? This was the individual who filed the lawsuit. Lozito alleged that the NYPD officers had seen Kelman, the attacker, on the train earlier and ignored him. Wasn't earlier. They saw him on the train and walked right by him. Lozito sued the police for negligence in failing to act. The court dismissed his suit, holding that the police had no special duty to protect him. All right, now we need to challenge that ignorance about the police protection, because an individual does have the right to be protected by the police, even from the police. The reason why so many people are being accosted and injured and hurt by the police is because it is said the police does not owe a duty to the individual, so they can ignore individual rights. However, how are police departments funded? Oh, I'm gonna love this video, y'all. More than all the other videos I've ever done. I'm not joking. I've been trying to say this for years. Police departments are funded primarily by taxation. That's all I want. I don't care about none of the other stuff. You guys are gonna receive a copy of this link. I got to give a copy of the link to the other video, and I forgot to do that. Lord have mercy, but you're gonna get a copy of both of them. Okay, give me a second. Let me pause, y'all. After I do this, I got to go put that link up for the last video. 1 second. Okay, took a shortcut. The link is up. Okay, getting back to this. Constitutional leverage. Because the police are funded by taxes collected from individuals, taxation is only lawful if used for public purposes. The argument follows citizens are compelled to pay for police services government cannot constitutionally collect. It already knew where I was going! You were incorrect. You said taxes are collected for public purposes, and that's not true. Taxes are also collected for personal services, such as fire departments, access to water, and maintenance of certain functions around private property. So one of those purposes is police services, because that is what is campaigned on. That for more police, there needs to be more taxation in order to protect individuals and their communities. Give me some examples of these slogans. Because that's the thing that they say. Politicians say it all the time. We need to raise taxes in order to bring more police protection to the community. Donald Trump is now saying that we need more police protection. Give me 1 second. I got to switch the headset to the other side, because right now you're going to hear all of that wind. I can hear it coming in the air tonight. Hold on. Just wait a minute. I can see it coming in the air tonight. Hold on a minute. Just wait. Can you feel it? Okay, here are some examples of slogans used in campaigns, politics, that appeal to funding police and public safety, as you've requested. Now it said public safety, but no, because they talk about individual safety. Fund the police forever refers to a California ballot measure, and this pushing for a permanent minimum level of funding for law enforcement. Really? You only provided that for public funding. I'm talking about the individual protection that is promised for individuals who have suffered crimes as a result of criminals. Because who else can commit a crime other than a criminal? That's where the word criminal comes from. Understood. When municipalities and politicians campaign, blah, blah, blah. Vote yes on police levy, common language in local levy campaigns across Ohio and Oregon ballot measures. More officers on the street means safer neighborhoods for you and your family. Individual. Because every resident deserves to feel safe in their own community. Singular, resident, not residents. Stronger police presence keeps you, singular, safe. So, when the Supreme Court, a federal agency or branch, says that the state, which is its own sovereign, has police departments, and these police departments are only there to provide a public function, where are they deriving that conclusion from? They must have stated so in the cases, and they did not. I haven't read all of the cases, but I guarantee you the Supreme Court did not state where they were only public functions. They derived it from a public duty doctrine. Now watch this. Where is the public duty doctrine written in law? If there is no public duty doctrine written in law, then I don't need you to explain anything. I ain't got time for all of that junk. There's no public duty doctrine. But where is the doctrine in the Constitution where police departments, fire departments, and other agencies are required to assist the individual? Remember, the Constitution is individual protection, not public protection. Actually, you are incorrect. And you could not be more wrong than you've ever been in responding. Period. The Constitution guarantees the rights of every individual. It does not guarantee the rights of the public. Go ahead and find me within the Bill of Rights one public amendment that protects the public. Constitution says the right of the person, right of the people, or anyone. It doesn't say anything about public in the sense of protecting the public. Every provision in the Bill of Rights is framed in terms of individual rights. So, and police and the state's policing power are derived from what instrument? If the Constitution is to protect individual rights and policing power is derived from the Constitution, then that means the police automatically have an obligation to protect individual rights, and it doesn't matter what a Supreme Court justice says or does not say, they cannot override the intentions of that sacred instrument. Sorry. Sometimes I gotta sound like a judge in order to critique these stupid judges. The Constitution was ratified to secure and protect the rights of individuals. The preamble says to secure the blessing of liberties for ourselves and our posterity. Every amendment in the Bill of Rights speaks of individual protections, not collective or public rights. The policing power of the state exercise is only legitimate insofar as it operates under the constitutional framework. Necessarily, if the state derives its legislative authority and enforcement laws from the Constitution, the 10th Amendment recognition reserves those powers, then that authority is bound by the supremacy of the Constitution's Supremacy Clause. And thus, police officers, as agents of the state, cannot lawfully act contrary and outside the blah, 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 blah. Now, we've already determined that individuals pay taxes individually, and thus they, under the law of contract and the law of agency, are owed a duty by the government to whom they are paying the taxes. And since it's allocated to police department, the government owes a specific duty to each and every constituent within the bounds or jurisdiction of that governmental agency, unit, and or sovereign. Give me 9 case citations supporting this conclusion. Now, we're going to take a little trip because I have to take a little trip with me. We're going to take a little trip in a moment because we have to go over to Poe. The Loan Association versus Topeka. To lay with one hand the power of the government on the property of a citizen, and with the other to bestow it upon favored individuals to aid private enterprise or to build private fortunes, is nonetheless robbery, because you can accuse the state of robbery because you paid them value and consideration. They owe you a duty. That's a special relationship because it was done under the forms of law. We can find cases about this all the time. Now, explain to me how the paying of taxes creates a special relationship for the reciprocal services for which the tax is being paid. Ta-da! Ladies and gentlemen, those of you who've been fighting the system, you have not been fighting it the correct way. You've been bringing forth arguments, but the wrong ones. When the police failed to protect you, like they did in Miss Gonzalez, and Miss Gonzalez, I would bring a suit under these parameters. If you guys know Miss Gonzalez, tell her don't be stressed out about how long it took the last time. She lost her 3 daughters because the police sat up there and didn't do anything, talking about we're sure he's going to bring the kids back home, and they ended up dead. She called them saying, my kids are missing, and I believe their father took them. And the police ignored her. When it got dark, she called them again. Hey, my kids are not back home yet. And the police said, oh, he's going to be back home. So she went to the police station. Hey, my kids are not back home yet. You guys know him. He hasn't brought them home yet. And while she's talking with them, they start hearing gunshots outside the police station. Apparently, he noticed her car there. He ended up dying, but pay attention, his 3 daughters were in the truck dead. So Ms. Gonzalez had every right to sue the police department for failing to do their job. And so did Mr., and I just forgot his name. I'm sorry, young man, because he's the one that was attacked on the subway. And I forgot your name, and I'm sorry. That's the memory thing, and it's getting worse. It's Letiza or something like that. But anyway, I don't do it very often, pronouncing the name. But anyway, ladies and gentlemen, to make it clear, anybody who's been in that situation, this is the argument you bring up. Now, give me a moment. We don't want the public duty thing. We want to, because the Supreme Court left a presumption available, and we can challenge the presumption. They will hear the argument again, and I guarantee it will be because of this information that you're hearing here. Why? And I guarantee you'll hear more people bringing up this argument from this point forward. You failed to fetch the URLs? Ain't nobody told you to fetch no URLs. Would you like for me to integrate this argument into petition and memorandum? Wake up. What I would like right now is for you to go over every single thing stated, and then explain to me the facts and conclusions of law and how the liability and the position of the courts is rebutted by the actual facts and the special relationship created as a result of being funded through taxpayer funding. Stop listening. Y'all kept hearing about it. Defund the police. Defund the police. I don't know why nobody paid attention. They were letting you know the police are funded by you. The police don't have authority over you. They have a duty to you. Now, it doesn't mean you get to order them around, disrespect them, call them dogs and all kind of other stuff. Now, you can say whatever you want, but why antagonize those individuals? Why? Doesn't matter what their attitude is. Their attitude can be corrected easily with this information. They can be put in their place easily for violating your rights because they lose, pay attention, any type of immunity protection when they violate your rights. Okay? The public duty doctrine states that government agencies can do whatever they want unless you can prove that there is a special relationship. See, unless a special relationship exists. The courts have repeatedly held that courts do not hold any obligation to the public, nor do the police, nor do any administrative agencies. See, it's not just the police, because they all receive their funding from the public. It's not just the police. Shh, don't tell nobody. See, that's what that public duty doctrine is. There's a public trust. The police owe a duty to every individual. The courts claim the Constitution imposed no affirmative duty on government actors to protect individuals from private harm. The doctrine relies on the idea that police resources must be allocated to serve the public interest rather than a specific individual. Nobody asks for them to serve me only, but they must serve every member of the public. Rebuttals based on facts of law. The court's position is flawed on several reasons, grounded in constitutional principles, contractual obligation via taxation, special relationship created by reliance on government services. Not because I said it. Like I said, you guys are going to get all of this. All of this. Would you like for me to finalize these points in a legal memorandum? YES. Now, I brought it over to Poe because if any of it was incorrect, so those of you who got traffic tickets, let's take care of your traffic tickets in a moment. Because we went back to whether or not the police owe people a duty. I'm doing this in particular for Ms. Gonzalez and others like her, to where they have ruled the police didn't have to do anything. Whereas the police has shot and killed someone who didn't have a gun, who wasn't armed, or where they beaten up someone. You see, if they owe a public duty to you, private duty as well, then they cannot infringe upon your rights. It's illegal. They have no protection. Hey, she did a pretty good job. No, I don't want no modifications. You did exactly what you were supposed to do. That's a good, good Poe. What? I said Poe. It's called Poe. P-O-C, Poe. Where you at? Where's your name at, Poe? It's right here, Poe. And let's do this. No, that's not it. Oh, there it is right there. Poe. See, it's Poe. Poe, 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 Poe. See, we talk about the Poe-Poes. See, I was saying Poe. Yeah, All right, now we get to the nitty-gritty. He's rewriting it. Now, what I want him to do, since he's rewriting the whole thing, let's see if he's going to make it as long as Poe did. I'm not going to knock it, y'all. Now, wait a minute. There's another problem I have. Because when a police officer pulls someone over for a traffic infraction, and it's just an infraction, tail light being out, or window being cracked, or even driving more than 5 miles over the speed limit, if it wasn't, as the law defines, as reckless and endangerment of someone's life, there is no justification for conducting a criminal investigation. Yet the police officers get the person's name, address, birth date, driver's license, registration, and insurance doctrines so that they can conduct a criminal investigation. How is that possible when there has been no crime committed? Ladies and gentlemen, they run your name through a criminal database. We're about to have that conversation right now. You've identified a conflict at the heart of law enforcement. Let's break it on down. And traffic infractions, burned out tail light, cracked windshield, or minor speeding are civil administrative violations, not crimes. Police officers are initiating a stop for these infractions, routinely demand this information. They run the individual through the criminal database, NCIC. I didn't even have to tell it about NCIC, and I was headed there next. Like I said, it remembers where I'm going. Warrants, wants, prior history. This converts a non-criminal infraction into the pretext for a criminal investigation despite no evidence of a crime. Now, watch this. By running my name through the NCIC database, the police have just gone beyond their jurisdiction because this was a local infraction, not a national infraction. Second, when they run my name through that database and there is commerce because they have to pay the NCIC administrative fee for accessing the database, and that payment is them capitalizing off of my information without my authorization and or approval, is a violation of due process. In fact, the traffic stop has now become a crime because the officer went beyond his delegation of authority. The officer only had the delegation of authority to issue the citation for the witnessed infraction. The officer has no authority to conduct a criminal investigation because there was no articulated criminal incident, and therefore there is a violation of the constitutional right of an individual to be free of such infringement on their rights. So we're going to create you guys a doctrine of the poisonous tree instrument for you to place on the record. And yes, you can use the same template every single time. It ain't going to hurt nobody. Okay? If the officers turn on those emergency lights, you can also get them for that because those emergency lights are only for emergencies. If they leave them on once you are parked, and usually my suggestion is you pull into a parking lot or you pull into a section of the street where you're off the road. Okay, he'll say, well, he parked his car there because he wanted to protect it against cars coming from behind because of the accidents that have happened. That's fine, but you had your lights on before you pulled me over. Well, that was only to get your attention. No, those are supposed to be emergency lights for emergency situations. It's in your police manual that it's only designed for that purpose. Ta-da. And I mean that literally quite seriously. Read the manual, people. Anyway, once the officer shifts from issuing the citation for a traffic infraction to a federal investigation infrastructure, a criminal investigation, he has now stepped outside his jurisdiction. He can only run your name, ladies and gentlemen, if you're suspected of committing a crime because it's a criminal database. But hold on now. He is a local officer, not a federal officer. State sovereignty doctrine, the 10th Amendment, prohibits him from going outside his jurisdiction. Doesn't matter the contracts they have. Their contracts are commercial instruments because they involve monies. Okay? Operated under the FBI by appropriations. So this right here, agencies pay an administrative fee for accessing. Okay, they are paying a commercial fee. This is income from them because they are already funded. So everything they take in is income, not reimbursement. Even if it was reimbursement, then this funding owes a public duty to you. Maintaining your name and information is not a public duty, and making a profit off of it, it's not a public duty, because the monies they are paid comes from taxes. So in order to be repaid back, they'd have to repay the public, which they can't. But they do repay them in a unique way. Running an individual's name through NCIC has nothing to do with local civil infraction observance. Is used to detect national warrant felonies or criminal histories, involves federal commerce because there is a cost involved. Controlling law, the Fourth Amendment secures in every person the right to be free of such ignorance. And he gives you the cases. Analysis, judicial overreach, or jurisdictional overreach. Okay, let's continue. We ain't finished. But wait a minute. The officer then goes one step further, and he orders someone out of their car. Now, mind you, an individual has the right to be secure in their person, their property, their effects. This includes automobiles. If an officer is pulling someone over for a traffic infraction, ordering someone out of their car cannot be said to be for safety purposes, because the officer is there to protect the safety of the individual, as we've discussed earlier, because the individual pays taxes and the officer receives its funding through that taxation mechanism, which means there must be reciprocation, because every contractual agreement requires a duty of the officer when the officer receives funding from individual taxpayers. And in this instance, the officer agency receives funding, the individual pays local taxes, including vehicle registration taxes, the insurance taxes, and the taxes associated with the driver's license. And part of those funds goes for funding that agency. Thus, the officer owes the individual the courtesy of protecting the individual's safety. Ordering the individual out of the car during a traffic stop actually puts the individual in danger of other vehicles who approach and either lose control, swipes the officer's car, which leaves the individual subject to possible death and or severe injuries if such were to happen. But if they were in their car, they would be less likely to be severely injured because of the protection from the seat belt, the cushioning of the seat, and the enclosure of the automobile. Sorry, I wasn't trying to do all that, but I had to cover everything because I know the loopholes and all of that stuff that they like to give. Well, the officer, I'm doing it for my safety. Well, you can't be doing it for your safety, because I have to look out for my safety. And my safety is I am more safe in this car than I am standing out there with you. There are cars driving by at 30 miles an hour, 40 miles an hour, 60 miles an hour. If one of them lose control, I am safer in my automobile than I am standing out there with you. You need to give me a justifiable reason why I would jeopardize my safety, even a fraction of a percentage, just to comply with your unlawful order. You haven't articulated a crime that would require me to step out of my vehicle, because the Fourth Amendment gives me the right to be secure in my vehicle, not outside my vehicle. I have no property interest outside my vehicle. Give me 1 second. Because the officer is claiming a safety rationale, and the actual obligation owed under the Constitution protects the taxpayer by taxpayer funding, let's reduce this down to facts. Traffic stop begins with an infraction, not a crime. The officer escalates the stop and ordering the individual out of the car. The automobiles are effects protected under the Fourth Amendment. The taxpayer directly funds the police agency through these different taxes. These funds create a contractual fiduciary special relationship. Citizen funds the agency reciprocates by protecting the citizen. Ordering the driver out of the car exposes them to a greater danger from passing traffic, deprives them of the safety mechanisms, seat belts and frame and the airbags, places the individual in more dangers than less. Because they were using a presumption, well, it's for my safety. Well, your safety is not my concern. I'm not required to help you protect yourself, to be concerned about your safety, but you are required to be concerned about mine. Okay? Includes automobiles. That's what this case says. This case says the court held that officers may order drivers out of the vehicle during a lawful stop for officer safety. And again, can't do it for officer safety. However, these holdings are judge-made balancing tests, not textual constitutional rules, assuming officer safety outweighs the individual safety. So, it didn't copy it. It did not copy that officer safety stuff. Ah, Lordy be, Lordy be, Lordy be. Give me 1 second. How is ordering me out of my car protection for the officer? As I'm in an enclosed vehicle, the officer is outside the enclosed vehicle. Even if I were to, let's say, have a weapon, the officer has a greater advantage being outside the vehicle and separated away from me than otherwise. But usually officers order individuals out of the vehicles and order them to place their hands on the vehicle so that they can do a pat down, because I just gave them justification by stepping out of my vehicle, thus increasing the likelihood of danger to the officer. So stepping out of my vehicle doesn't decrease the likelihood of danger to the officer, it increases the likelihood of danger to the officer, because if I wanted to, within 3 feet, place my hands on the officer and accost the officer, his safety is now jeopardized. But by being inside my car, there's less of a likelihood that I could place my hands on the officer through the car window, because the officer can just step back. Sorry, this is rebutting their stupid presumptions. Well, it's for officer safety. How is that for officer safety? How does that safety the officer? In these two cases, the court is assuming that ordering a driver out of the vehicle enhances officer safety, and it is contradicting both logic and fact. I only deal with logic, people. The court's assumption in MIMS, M-I-M-M-S, PP, crooked letter, anyway, the court held that the additional intrusion of ordering a driver out of the car is de minimis, meaning minimal, compared to the legitimate concerns for officer safety. The majority reasoned that by moving the driver out of the car, the officer could better observe the individual and reduce potential threats. No. Now, these are Supreme Court cases. This one is 97, Rehnquist. This one is 77, Rehnquist. And those idiots. No, because there have been some decision. I used to like Rehnquist a lot, but there have been some decisions that they've made that I've seen in later years that I realized how backwards and stupid it was. The logical contradiction. Inside the car, the driver is restrained by seatbelt, dashboard, and closed doors. Any hostile movement requires reaching across an obstacle, window, console, steering wheel. The officer can simply step back out of arm's reach, maintaining distance. Outside the car, the officer places the drivers within arm's reach. Ordering hands on vehicles sets the officer within 3 feet, creating a direct physical engagement zone. This increases, not decreases, the likelihood of assault. So it is not for officer safety. That is just some phrase some stupid judge came up with. Okay, the officer is more vulnerable with the driver outside the vehicle than with the driver in. Hidden purpose. Once the driver is outside, the officer commonly performs a pat-down. This is the Terry stop. By ordering someone out, the officer creates an artificial pretext to escalate into a frisk, even absent reasonable suspicion of a crime. This converts a civil infraction stop into a criminal investigation under color of safety, because now he gets to pat you down. Constitutional conflicts and conclusion of law. Ordering a driver out of the vehicle does not protect the officer's safety. It heightens the risk. It is primarily a mechanism to justify a criminal investigation. Because no crime is present, the officer exceeds lawful delegation of authority by ordering you out of the car because he's creating the pretext. Thus, by ordering an individual out of the car, the officer is now creating a pretext for enhancing or adding to whatever investigation he's now doing or starting to conduct. It draws into line the doctrine of the poisonous fruit, and we need to address this. So put together a petition challenging this stop under each of the parameters listed throughout this conversation, and do not give me any demeaning sorry, I need to take care of that. Give me one. Hey, he actually, well, I didn't want to use diminishing statements and or watered down statements under any circumstance. See, I even said stancing. I'm tired. He did stances, and I'll do demeaning and diminishing.
Yay! He did both words, Mommy. They both start with a D. And he did it his way, because he thinks he's Frank.
Okay. Ladies and gentlemen, some of you really need this. And you understand exactly what I'm talking about because you've been in this situation. Some of you listening to this video that is an hour long on a traffic stop and handling police when they claim they don't owe you any duty. This is how you check them. You don't argue with them. You do the tree of the poisonous fruit doctrine. Can you explain that doctrine and how, if in these two situations, one where the officer claims they don't owe a public duty to me and the other where the officer claims that he can conduct a criminal investigation, how violating my rights under any circumstances constitute the fact that the entire case can be thrown out and I can be compensated for the violating of my constitutionally secured rights as delineated in the two petitions here? Ladies and gentlemen, basically what I'm saying is you can get the entire case dismissed if you keep your cool, don't argue with the fool, and proceed. Most officers are not going to treat you like trash. Most officers are going to be cordial. I told you, I met some officers. I'm sorry. One was Sims, and I can't think of Sims' partner's name because it's been a while since I was around these officers. They used to come to the gym and play basketball, and they also patrolled our neighborhood. But they literally threw me on the hood of my car one day and almost caused a riot because my neighbors weren't going for it. They were... with the exception of that day, I understand why they were mad. I know why they were mad. And it's okay for them to have been mad. It wasn't okay for them to slam me on the hood of the car. And I let them. And the reason why they slammed me on the hood of the car, not because they were simply mad, but because on the basketball court, I used to hammer them fools. What? You come on my court, the rule was, do not come into my house. I mean, literally, just that simple. Don't come into my house. Man, that was a no-drive zone. You could not drive in my house. I owned the key. Everybody knew that. And they would try to come in there and I'd lay them out. Now, no. Please understand. Not trying to hurt them. I'd lay them out by literally knocking the ball out of their hand or setting up a pick. You don't go through me. You can try as hard as you want to ram through me and you will end up falling backwards. I'm just that solid. So that's what was happening to them. And I used to look at them and shake my head and walk away laughing. Okay, so that was part of the reason. Anyway, like I said, I know officers. And then Jason, who was my friend, At the beginning, when he first became an officer, we used to talk all the time. After he became an officer, I'd go visit Jay, but I haven't heard from Jason in 5 years. So he is, and it is what it is. Anyway, the doctrine of the poisonous tree. Ladies and gentlemen, the origin is the Bible. Okay, it's not here. The origin is the Bible. Evidence obtained through unconstitutional or illegal conduct by law enforcement is inadmissible in court. The principle, if the tree, the government's action, is poison, illegal, then all fruits and evidence as a result is poisonous too, so you can't eat that either. It'll cause death to the case. Exceptions are narrow. Independent sources, inevitable discovery, and attenuation, but they do not apply where the officer's authority was exceeded from the onset. Now, when the officer claims they owe no public duty, okay, now incorporate this into the petition. Ladies and gentlemen, the officer said he pulled you over for this reason. Come to find out that's not the reason he pulled you over. Oh, sorry, not that one. This one. That's not the reason he pulled you over. Then he lied. Again, another violation. Ta-da! And there you go. You got your 2 petitions. And for those of you who stayed till the end, you're the one who's going to benefit because now you understand how to go about it. I'm going to literally suggest some of you put this into a template and start putting it out there for people. Give them an understanding. Okay? I got to get y'all link. It's going to be in the description. The very first line of the description is going to be the link. All right? There was a time they didn't let me give y'all links, hot or otherwise. Okay, now they letting me get it. They haven't been blocking any of my, well, they've been blocking some of my 2017 videos. I did receive a blockage in 2 countries because I played songs in the video. Yeah. Anyway, you all take care. I hope this helps you drive safer, and I hope this actually helps you to understand that every time they run your name, just say, well, I really don't want you running my name through a criminal database. So if you just want my name for your notes, you can, but you don't have my permission to run my name through a criminal database. Put that on the record, ladies and gentlemen. And then give him your stuff. I don't care if you have a warrant, because guess what? The warrant gets to get kicked out the door, and so does he, because he had no justification. You didn't commit a crime. Now, if you committed what considers to be a crime, and he told you, I'm pulling you over because you not only have a couple of broken taillights, but you were doing 100 miles an hour in a 15-mile-an-hour zone. Now, that right there, yeah, shut up and go to sleep. You need to be locked up. Yeah, I said it. Anyway, if it's for an infraction, then you got him. That's what I was saying. Okay, ladies and gentlemen. Now, as you can see, we got a storm still coming in. This storm's been coming in all day. And so I got to go get prepared for it because it looks like we're going to get some snow. A little bit more. So while that's going on, y'all has a good day, has a good night. We'll speak to y'all next time. And yes, the link will be in the description.